The birthday cake was still on the table when my son-in-law decided to end my life as I knew it. Not literally, though I would come to understand that his intentions were not entirely metaphorical either. He stood up from the far end of my dining room table, wine glass raised, 12 of Claire's closest friends and colleagues watching, and began what started as a toast to his wife's 40th birthday, and ended with something that made two women at the table go completely still. "And of course," my son-in-law said, his smile easy, his voice carrying the practiced warmth of a man who sells commercial real estate for a living, "we all want to make sure Harold is taken care of. I think everyone here has noticed, and we've talked about this, as a family that Dad hasn't quite been himself lately. Forgetting appointments, repeating stories, losing track of things. Claire and I have discussed having him evaluated. We want what's best for him. We want to make sure he's protected." He lifted his glass toward me with a small, solemn nod, "to Claire, and to making sure the people we love are properly looked after." Glasses clinked, but the sound was uncertain. A few people didn't raise theirs at all. I sat at the head of my own dining room table, in the chair I had occupied for 23 years, and I looked at my son-in-law. He met my eyes with that same calm, practiced smile, the smile of a man who had just planted something and was waiting to see what grew. The smile of someone who believed he had already calculated the outcome. He had calculated a great deal. He had simply calculated it wrong. Before I continue, please subscribe to the channel and leave a comment telling me what time it is where you are right now. My son-in-law had moved into my home 16 months before that dinner. The explanation he and Claire offered was straightforward. A commercial deal he'd spent 8 months structuring had unraveled when a key investor pulled out, and they needed somewhere stable while he rebuilt. Claire called me on a Sunday evening, apologetic but confident it would be temporary. 3 months, she said. Maybe 4 at the outside. I said yes because she was my daughter. I said yes because my wife Claire's mother had died of pancreatic cancer 2.5 years earlier, and the house on Linwood Drive felt too large for one person, and I had told myself that having them here might be good for everyone involved. I said yes because I am 67 years old and I spent 35 years as a forensic accountant in the Criminal Investigation Division of the IRS, and I like to think I am a reasonable man who gives people the benefit of the doubt before the evidence suggests otherwise. The evidence began suggesting otherwise within the first 6 weeks. He worked from my kitchen table, spreading his materials across the surface in a way that left me effectively excluded from my own kitchen during his working hours. He parked his truck squarely in the center of my 2-car garage, angled in a way that made the second bay unusable, which meant my own car sat in the driveway through 2 Tennessee winters. He adjusted the thermostat without asking. He replaced my coffee brand with one he preferred and left mine in the cabinet like a relic. He made comments always framed as helpfulness about the neighborhood, the house, the market value of properties in the area. He called my home an asset. He called my 23 years of accumulated life in this house square footage. He said things like, "It's a seller's market, Harold. A man your age, rattling around in a place this size, people would pay serious money for this location." I said nothing. 35 years of sitting across tables from people who had embezzled from pension funds and falsified corporate returns teaches you the value of silence as a professional posture. Silence is not absence. Silence is attention. Silence is the space in which people show you exactly who they are, because they fill it. By the time the birthday dinner arrived, I had been filling that silence with notes for 4 months. I had noticed small things, which in my experience are rarely small. A file I maintained in my home office property deed, account statements, trust documents, beneficiary designations, insurance policies, had been disturbed. The papers were not in the sequence I kept them. I do not misplace things, and I do not reorganize files and forget having done so. This is not vanity. It is the result of 3.5 decades of work in which a misfiled document could mean a case fell apart. I did what I had done in the field when I suspected unauthorized access to records. I replaced the folder and placed a small piece of clear tape across the interior edge of the drawer, positioned so that it would break invisibly if the drawer was opened without knowledge of it. An old habit, one I had not expected to need in my own home. 3 days later, the tape was broken. I said nothing. I moved the file to a locked briefcase in my car and began keeping my most sensitive documents elsewhere. And then, 16 months after they arrived, my son-in-law stood up at his wife's birthday dinner and told 12 witnesses that her father was cognitively declining and needed to be evaluated for his own protection. After the guests left that night, I stood at my kitchen sink and replayed the toast word by word. Not from memory, I had made a quiet note on my phone under the table during dessert, the way I used to make notes in the margins of interview transcripts. His exact phrasing, the specific behaviors he had named, the legal framing embedded in ordinary language. Concerned, evaluated, protected, looked after. This was not an impulsive comment from a worried son-in-law. This was constructed, delivered in front of witnesses, designed to establish, in the minds of people who knew me, a pattern of cognitive concern. I had spent 35 years building cases. I recognized the architecture of one being built against me. I went to my study, closed the door, and sat at my desk. My reflection was faint in the darkened window glass. A 67-year-old man with gray at his temples, and the expression I used to wear when a set of books didn't balance, and I was about to find out why. A man who delivers that kind of toast doesn't do it because he's worried. He does it because he needs that worry to exist on record. He needs people to remember it. He needs it to be the kind of thing that, later, others will say they noticed too because he told them to notice it before they had any reason to. The word arrived in my mind with the quiet certainty of a number that finally makes a column balance. Conservatorship. If a person can be shown, to the satisfaction of a court, to be incapable of managing their own affairs, that court can appoint someone to manage those affairs on their behalf. Their finances, their property, their decisions. My son-in-law had been in my home for 16 months. He had accessed my files. He knew the rough shape of what I owned. He was carrying debts I didn't yet know the full measure of, but I could feel their outline the way you feel the weight of something concealed before you've uncovered it. I did not sleep that night. I was already working. The next morning I made 3 calls. The first was to a former colleague, a woman I had worked alongside in the Nashville field office for 14 years, now operating as a private forensic financial consultant. I told her I needed a comprehensive financial portrait of one individual, including all entities, all liabilities, all court filings, and any legal consultations she could locate through legitimate public record channels. "How deep?" she asked. "Until there's nothing left to find," I said. The second call was to my estate attorney. I had a meeting with him Monday morning. There were documents I needed to review and, depending on what I found, likely revise. The third call was brief. A former colleague now working in private investigation. I gave him a name and asked him to monitor for any legal consultations with elder law firms in the greater Nashville area associated with that name. I paid all 3 retainers from an account my son-in-law had no knowledge of. Then I drove to the hardware store, bought 2 deadbolts, and installed one on my study door and one on the door to the room where I kept my records. My estate attorney and I met for 2 hours on Monday. He was a careful man with 20 years of professional trust built between us, and he did not waste either of our time on questions he already knew the answers to. 3 months earlier, on instinct I could not yet fully articulate, I had transferred the house into a revocable living trust. It was the kind of protective measure I had watched other people fail to take, and I had done it without being certain why I felt the urgency I felt. Now I understood the instinct perfectly. My attorney drafted 2 additions. The first was an amendment to the trust, reinforcing its structure against any external petition for management of the underlying assets. The second was an update to my will containing a provision I had spent considerable time phrasing with precision. My daughter would inherit the home on Linwood Drive, my retirement accounts, and the remainder of my estate on the condition that she was legally divorced from her husband at the time of my death. If they remained married, the entirety of my estate would pass to the Community Foundation of Middle Tennessee. "This is enforceable," my attorney confirmed. "I know," I said. "Draft it properly." He looked at me over his reading glasses. "The trust structure also makes any conservatorship petition essentially moot. The assets are held by the trust, not by you personally. There's nothing for a guardian of the estate to manage." "That was the idea," I said. He allowed himself a small, satisfied expression. Good attorneys appreciate elegant solutions. I asked him to send a formal notification letter to my daughter by certified mail. Professional language. No specifics, simply informing her that her estate planning documents had been updated and that conditions now applied to her inheritance. I wanted her to have the letter before anything else happened. I wanted her thinking about what it might mean. The letter was delivered 6 days later. My son-in-law signed for it. My colleague's report arrived on a Tuesday, 39 pages delivered to a secure email account. I read it at a diner on 8th Avenue with black coffee and the particular stillness of someone who has been in this situation many times before, the moment when the numbers stop being abstract and become a picture of a person's actual life. 4 business entities. 2 dissolved. The third was the vehicle for the investment deal that had collapsed. Except the collapse had been engineered to a specific purpose. Losses absorbed by the entity, certain management fees redirected to a personal account in my son-in-law's name. My colleague called it aggressive, self-dealing, and underlined the phrase, personal debts, 3 installment loans, 2 lines of credit fully drawn, credit card balances across 6 cards, totaling $67,000, and a civil judgment from 14 months ago. A subcontractor who had not been paid resolved quietly before it could become a matter of public attention. Total personal liability, just over $98,000. I turned to the final tabbed section. My colleague had located intake records from an elder law firm in Brentwood. The consultation had occurred 9 weeks before the birthday dinner. The name on the intake form was my son-in-law's. The subject was described as family member, 67, potential cognitive decline, asset management, and protective oversight, 9 weeks. He had been consulting attorneys for 9 weeks before he stood in my dining room and told 12 people I was losing my mind. The birthday dinner had not been the beginning. It had been a milestone, a documented moment of public concern, delivered in front of witnesses he could name, placed in the timeline of a case he was building. I set the report down. I finished my coffee. I paid the bill and drove home. I did not tell my daughter what I had found. Not that day, and not for the days that followed. I want to explain why. Because I have heard people say that I should have gone to her immediately, that she had a right to know, that waiting was a form of withholding. I spent 35 years watching people receive truths they were not yet ready to hold. When you hand someone a truth before they've arrived at the space to receive it, they resist it. They explain it away. They protect the thing the truth threatens, because protecting it feels like protecting themselves. I had watched prosecutors lose cases this way, presenting everything too early, before the person across the table had run out of defenses. My daughter loved her husband. She had loved him through the collapsing deals and the moved-in months, and the adjustments and the small erosions of the life she'd imagined. That kind of love doesn't release its grip because someone tells it to. It releases when it runs out of things to hold on to. So I waited. I watched. And 6 weeks after the birthday dinner, on a Tuesday afternoon when my son-in-law was out and my daughter was looking for a specific insurance document in his files, she found the credit card statements. She came downstairs at 4:30 and sat at the kitchen table the way people sit when the floor has gone uncertain under them. I put a cup of tea in front of her. She didn't touch it. $67,000, she said. I know. She looked up. How long have you known? A few weeks. Dad. There was something close to anger in her voice, but beneath it, something much more frightened. Why didn't you? Because you needed to find it yourself. If I had brought this to you, you would have found an explanation. You would have defended him. I know how you love Claire. You love the way your mother loved completely, all the way to the edge. That's not a flaw, but it means the truth has to find you, not the other way around. She was quiet for a long time. There's more, she said. Not a question. Yes, I said. But not today. I gave her the rest in pieces. Over 4 days. The business entities, the judgment, the failed deals, and the money that had moved in directions it shouldn't have moved. On the 4th day, I put the elder law firm records on the table in front of her. The intake notes, the consultation summary, the phrase, potential cognitive decline, asset management, and protective oversight, his name on the intake form, the date, 9 weeks before her birthday dinner. She read it twice. She set it down and pressed it flat with her palm, smoothing edges that didn't need smoothing. He told them you were forgetting things, she said. Yes. He was going to petition the court. She said it slowly, assembling the shape of it as she spoke. He was going to tell a judge you couldn't manage your own affairs. That appears to have been the plan. And the toast. At my birthday. In front of everyone. A public record of concern. Witnesses he could later identify by name. She pressed the papers flat again. Something was moving behind her eyes, a woman who has loved someone without reservation beginning to understand that the thing she loved was not quite real. I have watched this in interview rooms. It is one of the hardest things to witness, because there is nothing you can do to make it faster or slower. You can only be present. I'm going to make a call, she said. I got up and left her the room. She found her own family law attorney. I did not give her a name. She came home from the initial meeting on a Thursday afternoon with red eyes and a steady voice. I signed the initial paperwork, she said. Okay, he's going to come home tonight, and I want to tell him myself. I don't want him served by a process server without any warning. She paused. Even after everything. That's who you are, I said. That's not a weakness. She met his car in the driveway when he came home at 7. I stayed inside. Through the kitchen window, I could see them, my daughter, standing at the edge of the driveway, her arms folded against the evening chill, and my son-in-law listening as his face changed from confusion to disbelief to something harder and colder. He looked toward the house, toward the window where I was standing. I held his gaze without moving, without expression. He looked away first. The weeks that followed moved with the particular efficiency of consequences meeting their destinations. His attorney's office requested a full accounting of the marital estate. What they found, or rather, what they did not find, appeared to be a surprise. The house was held in trust, not jointly. The retirement accounts were titled in trust. The significant financial decision that my son-in-law had described to the elder law attorney as evidence of my cognitive decline was, in fact, a careful and legally airtight reorganization of my estate executed months before his first consultation with that firm. His attorney sent a letter suggesting that the trust transfer might be contestable as marital asset manipulation. My attorney responded with the notarized trust documents, the date of transfer, the clear chain of title, and a brief, precise sentence noting that the transfer had been completed 41 days before any consultation records associated with my son-in-law's name appeared in any court-adjacent filing. I received no further letters on that subject. My son-in-law moved out on a Saturday morning. He had arranged a moving company, which was the most organized thing I had seen him do in 16 months. I stood in the doorway of my study and let the process proceed. When he passed me on his last trip out a box of files under one arm, his expression the specific blankness of a man who has run out of moves, he stopped. You knew, he said. You knew the whole time what I was doing. I suspected, I said. Then I investigated. Then I knew. You're 67 years old. You live alone. If I had. I am 67 years old, I said. And I spent 35 years investigating financial crimes for the federal government. The house was in a trust before you filed your first intake form. The estate was restructured before your second consultation. There was no version of your plan that reached a favorable conclusion, because I had closed every door before you finished reading the floor plan. He stood there. I watched him search for the frame in which he was reasonable, and I was the obstacle. People like my son-in-law always need that frame. They need the story in which they were simply resourceful, and the people who stopped them were simply obstacles. It's how they've moved through the world. You could have just talked to me, he said finally. If you had concerns, you could have. You could have just not accessed my private files, I said. You could have not spent 9 weeks consulting an elder law attorney about petitioning for control of my assets. You could have not delivered a performance at your wife's birthday dinner designed to establish, for witnesses, a pattern of my cognitive decline. We could both have made different choices. I made mine. They happened to be better documented. He left without another word. The door closed behind him. I listened to his truck back out of the driveway. Then I went to the kitchen and put on coffee. My daughter moved fully back into the house 5 weeks later. Her old room was unchanged. I had kept it as it always was, but she repainted it the first weekend, a warm yellow that came from a paint chip she'd been carrying in her wallet for 2 weeks before she chose it. "Something that feels like the future," she said, holding the chip up against the wall. "Good choice," I said. She was in therapy twice a week. She was sleeping through the night. Some mornings she was in the kitchen before I came down, and the sound of someone else moving through the rooms, someone who was meant to be there, was something I had missed for 2.5 years, without fully knowing I was missing it. 2 envelopes arrived on a Thursday in early November. Hers was from the court, the final dissolution decree. Mine was from my estate attorney, confirming that the trust had been updated and that Claire was now the direct and unconditional beneficiary of everything I had spent a working life building. We read them at the kitchen table, each of us reading our own. "It's done," she said. "It's done." We sat with that for a while. The way you sit with something after it's finished and you're not yet sure what the quiet means. "Dad," she said eventually, "were you ever afraid?" I thought about the question seriously, because it deserved a serious answer. "Not afraid," I said. "Angry. Briefly. The night of the dinner. Then focused. Fear is for situations where you don't know what to do. Once I knew what to do, there was nothing left to be afraid of." She looked at me across the table, in the afternoon light that came through the kitchen window the same way it had come through for 23 years, and for a moment she looked exactly like her mother. The same particular steadiness. The same way of looking at a person and seeing them clearly. "He thought you were just an old man alone in a big house," she said. "Most people in my career underestimated what they were sitting across from," I said. "It was almost always how we knew where to start." She smiled, the real one. The one I had not seen in too long. "I'm sorry I didn't see it sooner." "You loved him," I said. "Love isn't a failure of judgment. It's a different kind of attention. It sees what it hopes for. The other kind of seeing takes longer to arrive, but it arrives." It arrived. She nodded slowly, looking out at the backyard. The bare, late autumn trees, the sky going amber over the tree line the way it does in Nashville on a clear November evening. "I've been thinking about what I want the next part of my life to look like," she said. "Tell me." And she did. We talked until the light was gone, and then we moved to the porch with our coffee. And the night came in cool and clear and full of stars, the way it does here when the weather turns. We talked about what she wanted and what she was building toward and what she thought might be possible. And I listened the way I have always tried to listen, completely, without redirecting, without moving toward the end, before it arrives on its own. At some point, I thought about the toast. About 12 people sitting at my table while my son-in-law planted the story of my decline. About the broken tape on my drawer. About 47 pages of documented debt and deception. About the intake form with its careful language, potential cognitive decline, asset management and protective oversight and the plan behind it. And I thought about what he had not known, and could not have known, because he had never taken the time to actually see me. That the man he was attempting to diminish had spent 35 years learning exactly how to document the ways that greed constructs its cover stories. That the house he had come to consider an inheritance was already beyond his reach before he took his first consultation. That the evidence he had created, the intake forms, the birthday toast, the broken tape, the disturbed files, had all been cataloged by the person he was creating it against. He had handed me every tool I needed. People usually do. I do not wish him harm. I have genuinely wished very few people in my life harm. What I wish for is what the law was designed for. That choices carry consequences, that documentation matters, that the patient accumulation of truth outlasts any narrative built to contain it. My daughter is healing. My house is quiet in the way that houses are quiet when they belong to the people in them. The spare room has yellow walls now and photographs on the windowsill, and a woman in it who is building something new from the materials of a life she is reclaiming piece by piece. Some mornings I sit on the porch with my coffee before either of us is fully awake, and I think about the long arc of the thing, the 16 months, the tape on the drawer, the report with its yellow tabs, the attorney's office, the conditional clause, the moving truck pulling out of my driveway, and I feel something that is not quite satisfaction, and not quite relief, but somewhere between the two. The feeling of a column of numbers that finally balances. The feeling of a case properly closed. If this story meant something to you, please like this video, subscribe to the channel, and share your thoughts in the comments. For more stories, click the link to the left. Thank you for being here.